A new law has just been enacted called the Pregnant Workers Fairness Act. Now, Pregnant Workers Fairness Act was actually signed a few years ago, but it finally went into practice. Little history here. There have been laws that have protected pregnant workers for quite some time now. And this new law is more or less, I think, in my opinion, trying to better enforce the laws that are already been on the books for pregnant workers. So to put it at its 30,000 foot view, a pregnant worker really under the law is considered almost a disabled person. In fact, the Americans with Disabilities Act has always been a law that a pregnant worker could go to understand their rights during their pregnancy, because the way the law has viewed it is that pregnant workers need accommodations. There are times where, for a period of time during pregnancy, a worker may need special accommodations or may need certain considerations that a non-pregnant worker doesn't require. And there was never any specific law that outlined requiring an employer to give those accommodations. So the law turned to the Americans with Disabilities Act, or here in Illinois, the Illinois Human Rights Act, which has its own disability provision. And in those two laws, there were provisions that discuss how a worker could ask for a reasonable accommodation. What the Pregnancy Workers Fairness Act does is it enforces, it more clearly defines that a pregnant worker can ask for accommodations. In a way, it might even sort of take away this notion that they're a disabled person and separate it as its own unique thing, which is probably appropriate. But in doing so, it is ensuring that the pregnant worker has certain rights when it comes to asking for an accommodation. So what does all this mean? The Pregnancy Worker Fairness Act covers essentially employees with 15 employees or more. And if you feel like you've been suffering from discrimination, you can do what other discriminated people can do and file a discrimination claim with the EEOC. But hopefully you don't, because companies right now are revamping handbooks and making sure that all the right people are informed about what they need to be informed about as it pertains to this new law. The main thing here is that it allows an employee to what we call engage in the interactive process to determine a reasonable accommodation. Now, does this mean that an employee can turn to their employer and say, I'm pregnant, I need the next 9 months off, that's an accommodation? No, it doesn't mean that. What it means is that the employee has the right to have a conversation where both sides come together and discuss what is a reasonable accommodation for the employee. That means that they can't be ignored. The employer has to discuss this issue. But what a reasonable accommodation is a fluid thing. It really depends on the worker's job, their title, the sort of facilities that the worker works in, the sort of backup that the employer has to accommodate the worker by maybe including another employee to kind of help pick up the slack. It really is ill-defined, but it might be things like more extended breaks. Pregnant employee might need a 5-minute break once an hour. Given like maybe what's going on in their pregnancy, they might have to go to extra doctor's appointments. They might get tired more easily. I mean, that's not a might, it's almost a guarantee. So it might mean like working from home. There really shouldn't necessarily be a limit to what sort of request you can make. It's just that there is a limit to what an employer has to agree to. That's really the important thing here. When you engage in this interactive process to determine a reasonable accommodation, the real key word there is reasonable. It has to be that both sides agree that this is something that both can do. The law says that if the accommodation would pose an undue hardship for the employer, then they don't have to agree to it. And this can be something that can really draw consternation between employer and employee. The law has tried to define it as best it can. But what essentially it means is that the accommodation must be there so long as it does not affect the worker's ability to do the essential function of the job. So, what do we do there? We take the roles and responsibilities as they're defined by the employer. We look at what the sort of accommodation requested is, and we determine if we're checking off or crossing off a lot of the roles and responsibilities. And if we are, then it's probably an undue hardship. COVID really kind of put that into the spotlight because all of a sudden people started working a lot from home. Maybe it was hybrid, maybe it was exclusively from home. But as we've sort of gotten out of the pandemic, we've realized that a lot of people want their workers to go back to work. They want the offices to be filled. And so people are coming back to the job, but they know what it's like to work from home. And there might be a tendency to ask to work from home because, it was reasonable at the time and work didn't necessarily slow down or diminish. So a worker may be inclined to say like, well, it worked before. Why don't I just work from home for the next 9 months? And for the most part, the law has said that is not really a reasonable accommodation. It can be, but as sort of a blanket accommodation that'll work across the board, no, it's not. If one of the requirements is that the worker be at the job, then failing to meet that requirement might pose an undue hardship. Now, maybe there's a middle ground. Maybe it's that the worker needs to be home 3 days a week and comes into the job 2 days a week. It's kind of what both sides agree to so long as the essential functions of the job are still met. So it would not be a good idea for a pregnant worker to immediately say like, I just can't do the job for 9 months because I have to tend to my pregnancy. And I'm asking as an accommodation. If you aren't doing the job, you aren't performing the essential functions of it. So you therefore are posing an undue hardship for an employer. And that's the sort of thing that really won't work in the Pregnancy Fairness Act. It's those times where it's good for an employer or employee to give us a call so we can talk it through, because there just aren't any hard and fast rules here, but there are guidelines that have been sort of gone back to time and time again by the courts to define it as well as we can. But in many ways, we don't want to define it. We don't want to have it so strict because each situation is different. If you're a customer service rep who's just on the phone and needs a phone and a computer, like maybe it isn't reasonable for you to work at home for 9 months. Meanwhile, if you are working at a factory and you're overseeing 15 people and you have to monitor their safety, well, then it's probably not reasonable. It really all kind of depends on the job that you have. But suffice it to say, these laws that are on the books, they're really helpful. They continue to help define the rights of workers. They continue to help to give direction to the courts. They continue to help give direction to employers about really what society thinks is the most reasonable and right way to care for employees. It will be very interesting to see kind of what happens in the future. There have been a lot of calls for paid maternity and paternity leave. The US doesn't have that. If you have worked for a place for over a year and your employer has 58 people or more within 75-mile radius, you are entitled to FMLA leave, which is a very common leave for people who have just given birth, and that's 3 months, but it's not paid. So there are certain employers who will give a paid leave because they think it's the sort of benefit that might attract top talent, but it isn't a requirement. If you look across the world, it often is a requirement. So those are the sort of things that we might see in the future. There's a lot of other kind of legal changes that have just occurred. We just got a ruling on what an employer's obligations are in terms of servicing somebody who say they disagree with religiously or fundamentally or socially. We also got a ruling about affirmative action. Those things all have to do with civil rights. And while I think they apply in some way to the employer or the employee because that might affect kind of their life outside of work, and they certainly have something to do with civil rights, they don't really come into play in our line of work. But it's always interesting to see what happens in current events and kind of get an idea of how that might affect employment law. Because when you spend most of your waking life at a job or on the job, a lot of stuff affects employees, and a lot of laws are made to affect the lives of an employee. So stay tuned for more current events and more things that are changing the work life world.